But we also, under the 1999 forms of contract, you'll see that there's quite a lot of provisions that have the wording of unless otherwise stated in the contract. Yeah? And the question quite a lot of the time arises, where in the contract? Is it because if you remember, Bahati was pointing out the priority of documents. Is it in the specification? Is it going to be on the drawings? Is it coming from information from the employer? Or is it to be found in the contractor's proposal, in the contractor's tender? Is it in the pricing document? Where should we go to look to find it? And there's been so many problems caused by elements of that question being answered in different documents by different parties. And that sort of confusion just gives rise to lots of work for people like myself and Ian. So in the updates, you'll find that there's a lot more scenarios where we tell the parties exactly where FIDIC expects the information to be put. So you'll see there I've got a list of things that we expect the employer to include provision for in the employer's requirements, or say nothing. Deflect that, so that builds in flexibility for the employer to decide. Now, if the employer leaves it blank and the contractor puts it in his tender and that tender is then accepted, then it becomes part of the contract. But FIDIC believes that there should be a specific place where it's written. So you'll see the health and safety of personnel, more details on inspection, testing by the contractor, what software you want to be used for the program, and then procedures for techs after completion. And there's another list there as regards what might be included and what might not be. But fairly run-of-the-mill things, but each of them by themselves means that everybody knows what they should be working to. There's more certainty, less room for arguments, less room for ambiguity. Design, I've spoken about that a little bit more. There's more explicit requirements related to the designers itself. And again, remember, FIDIC is the Federation of Consulting Engineers. We want our engineers to be doing the design. So we're talking about engineers, but we also say our other professionals, because for building works, of course, you might have architects involved in that. When contractors documents then, contractors' documents, if you remember, they're basically the technical documents that the contractors submit showing the design, so there can be calculations or drawings or specifications or whatever. Under the employer's requirements, the employer tells the contractor which documents have to go through this review process. So that's another important thing to remember. Much more a step-by-step process of the contractor submits the contractor's documents. The engineer has a certain period of time to review them. He answers back with reasons why it can't be given a notice of no objection. The contractor has to revise and resubmit, all of that sort of thing. So you'll see that there's newly defined terms, a review period, what is a contractor's document, what is a contractor's notice. And I've already spoken about the defined term of no objection. And there you can see it's there. I won't read it out there. But under 5.1 then we say that the notice of no objection for design might include comments concerning minor matters which won't substantially affect the work. So that's reality. Reality is that quite often engineers like to say, yeah, that's okay, you can go ahead and build the works on that basis, but I want to add these little comments, yeah? So we wanted to try and keep the process quite strict, but to give the engineer and the contractor the ability to have this sort of scenario where, the design is fine, but just kind of bear these things in mind. And the reason for that was because in practice what was happening was engineers were writing letters that didn't quite, that contractors weren't quite sure whether the design was acceptable or not because there were so many comments in there. So we want to keep things now a lot more straightforward so that everybody understands what the scenario is. Bahati pointed out quite rightly that if an engineer issues an instruction, the contractor is under an obligation to follow that instruction. And that comes from a fairly fundamental principle, which I think underlines most standard forms of contract, and that is this idea of, Mr. Contractor, you do it now, and we'll argue about how much it costs later. Yeah? So that's not going to change. what we do think is very important is that so many times the engineer issues an instruction and he doesn't actually realise that that instruction is going to give rise to a change for the contractor in how he does something or the sequencing of doing something. Yeah. So in that scenario, then, if the engineer's instruction doesn't say this is a variation, which most of them don't in reality, and the contractor believes that it is an variation, then the contractor has the right now to give a notice that this is a variation. And then the corresponding right of the engineer is to go, yes, go ahead, or no, I'm going to revoke that instruction. So again, addressing what the real life situations, but trying to give the parties the flexibility for dealing with those as is best suited on a sort of case by case basis. And then we have all these subclauses here where it's made absolutely clear and explicit, where it wasn't so in the 1999 Forms of Contract, that the variation procedure is under clause 13 is to be followed, and that's correction of errors in employers' requirements, correction of errors in the items of reference, the engineer's instruction to deal with unforeseeable physical conditions, revised methods or acceleration to expedite progress, prolonged suspension and omission of the works. If the contractor fails to remedy, then the employer has the right to omit those works. So what happens in that scenario? You follow the variation procedure. And then damage caused by employer's risks. That's basically risks to the contractor's obligation to take care of the works. So that's basically how variations are dealt with. And I'll take this opportunity to remind you again that in valuing variations or in looking at EOT, that comes under the engineer's obligation under 3.7 to try and get the parties to reach agreement and then to reach a determination. So that means then that if all of that isn't agreed, it can go to the DAB, who are sitting waiting for this sort of things to happen because they've already been appointed at the start of the project. In practice, there's been some difficulties as well. This idea that we have the performance security, the performance bond, it's called a performance security under fitted contracts, which is a very useful tool for employers. But what happens, and if you remember, the performance bond is normally based on the value of the accepted contract amount. What happens if variations increase that amount substantially, but the performance bond is basically still down at the lower level, and then the contractor goes busters, terminated or whatever, and the employer realises that he's got this performance bond, but it's only worth a fraction of the actual costs involved. It's not worth what it should do. So in that scenario, we've basically allowed for the adjustment of the performance security if variations cause an accumulative increase or decrease of the contract price by more than 20% of the accepted contract amount. Now, the decrease will be what the contractor will ask the employer. Can I decrease? You've omitted that period, that element of the works. Can I decrease the performance security because it's costing me money and you don't need it anymore, or you don't need it? And then it'll be the employer that's looking for the performance bond to be increased if the variations cause the actual contract price to be increased. And that leads me on then to contract price and payment. We have a newly defined term called cost plus profit. And you'll be delighted to hear, I think, from what I've heard this morning anyway, that FIDIC believes that a reasonable percentage of profit is 5%. Now, I have presented something like this around the world, and I've been actually really quite surprised at the reaction to that, because I thought it was fairly much, in my naivety, I think, I thought it was fairly much accepted around the world that 5% was pretty okay profit, you know. And, you know, those people that were operating in the Middle East and in some parts of Southeast Asia were like, what, 5%? We normally have, well, that's absolutely too low. And I would pose the question, well, you know, what profit are you earning on your projects? These are contractors, of course, on your project. Of course, they were very loath to tell me that in open session. But, you know, a whisper in my ear later would indicate that they were making profits of 10 or 15% on bank-funded jobs. So I think therein tells a picture. But then you would have places like here in South Africa or Ireland, definitely, England as well, and parts of Europe, America, where 5% is really quite okay, and contractors will be delighted to receive it. And actually, in recent years, they've been operating as low as 2%, or even to go a little bit further back in time, -2%. But that's a different story. So anyway, FIDIC did take pay close attention to this percentage before they before they put it in there. It was discussed quite a lot. Friendly reviewers were asked to give their view on whether they thought that was reasonable or not. And if you remember, I said that there were quite a lot of contractors that were involved in the friendly review process. And the general consensus was, at the end of the day, that 5% was fairly okay. But that's just the default. If you leave it blank in the contract data, it'll be 5%. So if you want something different for your particular contract, you write it in there, whether you're the employer or the contractor. Generally speaking, employers make that, or we foresee that, generally speaking, employers will make that a tender assessment category, and the contractors will be allowed to put what they want in there. I would... Pardon me? Okay, so this is just profit. Ian has just mentioned head office overhead. This is just profit because the definition of cost, capital C, under FIDIC contracts includes overheads and profit. Okay, so, includes overheads. So this is just the profit side of things. Okay, and then we have provisional sums. Used actually quite a lot, and there seems to be a trend nowadays. I don't know whether you're seeing it here in South Africa as regards to provisional sums. It's a bit of a trend at the moment that quite a lot of things are bumped into the provisional sum side of things by employers. So we thought it would be useful to have a scenario where the contractor may be asked to submit quotations for goods or services to be provided under a provisional sum. And the engineer can then review those and point the contractor in the general direction of which quotation should be accepted. But it expressly states that pointing in the direction over that instruction to use a particular quotation doesn't mean that the supplier or the subcontractor becomes a nominated subcontractor. So for those in the room, don't let your eyes light up too far on that side of things. We've also got, if you remember, under the 1999 Forms of Contract, we have subclause dealing with adjustments for changes in law. We also want basically this reciprocity that we're trying to build into the FIDIC contract. We also want the scenario that the contract price can decrease if, for example, a law or a regulation or whatever is withdrawn from. It doesn't happen very often, but it has happened in the past. So again, that the employer should be entitled to a reduction in the contract price if actually the laws that the contractor has to follow have become a bit more favourable to him. And now we have adjustments for changes in cost. And you'll remember under the FIDIC books, there's a formula, a very complicated looking formula when you look at it first. It makes perfect sense when you've actually gone through it. And it refers to indices and everything. That, I don't think you guys would have any problem with it here in South Africa, but in certain parts of the world where they don't have published indices to refer to, it's caused untold problems where basically the contractor really should have gotten an increase in the contract price and he didn't because of the difficulty of using that particular formula. So now we say we're not going to specify any formula. You write in your particular conditions how that adjustment should be made. And then in the guidance notes to the particular conditions, we make reference to the formula as an example. Yeah. So that's how we're kind of trying to deal with that. And we also have advance payment. Now, I always say to people, and this I hope doesn't come to a shock with you guys, for you guys, but I always say to people that, and in my experience, and I think everybody that I've worked with in FIDIC or I've kind of come across in my working life, will basically say that the best aspect for cash flow for the contractor to make sure that the project is going to be successful is to keep the contractor in just positive cash flow. You don't want to give the contractor too much money because he might take off with the money. And at the same time, you don't want to underpay him all of the time, which employers and engineers regrettably do too often, because then he might start withdrawing resources from your project to send to another project where he is actually making better money or whatever. So the best case scenario is to try and keep the contractor in just positive cash flow. Now, exactly what that is a fine balancing act that the engineer has to, that fine line that the engineer has to tread, knowing that each of his interim payment certificates, while they have to be paid by the employer, the amount in them is on an on-account basis, which you all know, I'm sure, what it means. So if you paid the contractor too much this month or certified too much this month, you can basically take that off next month. But one of the things that is fairly standard, as I say, in the sophisticated construction world, but not so much in other parts of the world, is this idea of advance payment. And FIDIC believes that that's one of the best tools to make sure that at least the project as it starts out is going to be, the contractor is going to have positive cash flow. And so now in the general conditions, we have an express clause here. And again, it's on a step-by-step basis where the contractor is entitled to an advance payment. The amount of the advance payment or the installments, if that's what how you want to go, is in the particular conditions or in the contract data, but only if the contractor provides an advance payment guarantee. Yeah, so it's that balancing act and making sure that the contractor gets money, but at the same time the employer is protected. And then there's terminology as regards how that advance payment is to be repaid through interim payments. And so then we get on to the engineer's obligation to issue an interim payment certificate. And I'm sure it's the case here, but I'll just remind everybody that in England, Ireland, America, common law jurisdictions, the engineer's certificate, I can't remember which court case it was now because I'm not great at the names of court cases, but there was a recent court case that basically emphasised that an engineer's certificate might as well be a bank cheque for the contractor. It has the same sort of power. The court basically said that, I think it was an architect's certificate actually, one of you lawyers will remind me which case it was. And it's just emphasised to engineers in particular that when you certify payment, the employer has an absolute obligation to pay that, and he can't question it except by going through the dispute process. So we basically, in the new updates, you'll find that again, you're seeing sub-clauses here, so you're seeing a step-by-step process. The IPC will the amount that the engineer fairly considers to be due. Now, under the 1999 forms of contract, you know that the word is fairly determines to be due. Well, we took that word out because determination now means a different thing. It means a definite thing under the updates. So basically, we've got that word fairly, and we've got fairly considers to be due. So we see that the engineer is playing a sort of an assessment role, not a determination role. So just to sort of emphasise the distinction between the two. Now, if the engineer, and basically, the contractor makes his application for payment, and the engineer is under an obligation to look at the amounts that the contractor has applied for, and then basically pay that amount, except for amounts that he withholds. Okay, and then we get into 14.6.2. For the amounts that are withheld, so they're the amounts that the engineer does not consider are fairly due to the contractor. The engineer has to give a notice and detail his calculation of the amount that he was withholding and the reasons for it being withheld. Okay? So the contractor will always know why he's not getting paid this month what he applied for. Yeah? And sometimes that notice might just be, it's a claim still to be determined, or it's a dispute that the DAB is still working on, for example. And also, along with that, then we have this scenario where the contractor can identify what he thinks should be corrected or modified in next month's interim payment certificate. Okay, and then if the contractor is not satisfied with the next IPC, he can refer to the engineer for agreement or determination. Yeah, so that's that step forward. And then, of course, if the contractor is still not is satisfied with an agreement or a determination by the engineer himself now, then he can refer to the DAB and you have a dispute. So there you're seeing a fairly clear path towards a dispute scenario, which wasn't so clear under the 1999 forms of contract because there wasn't that definition of dispute. And so too many times employers were saying to the DAB, you have no jurisdiction to look at that matter, that issue of payment and interim payment certificates, because it's not a dispute yet. And contractors were then sitting there waiting for their money, trying to figure out how they were going to actually get paid. So unfortunately, that's a scenario where engineers and employers were abusing the FIDIC provisions. And so we're trying to take care of that now. Periods for payment. The periods of payment in the 1999 forms of contract was 56 days from the date of the contractor statement. And we realised that that suits some employers and contractors and it doesn't suit others, depending on the project, depending on the part of the world and everything. So now, basically, it's up to you. You decide what it's going to be, as stated in the contract data. So basically, there's a blank at the moment in the contract data and you put in those days. And there are default periods basically reflecting exactly what 1999 form said. So if you say nothing, this is what FIDIC thinks should apply. And the default periods are 21 days for advance payment after the employer receives the advance payment certificate, 56 days for interim payments, and 56 days from final payment. So it's basically what was in the 1999 forms of contract. Suspension and termination by the contractor. The employer, well, sorry, I'll reverse back. The employer has more or less the same rights to suspend the works as was under the 1999 forms contract. And the employer has the same rights to terminate under clause 15 as under the Yellow Book 1999 form contract. Well, we have a kind of a new concept. But I think it'll be very straightforward to you guys. And that's basically this idea of a notice of intention to terminate. So if you like, that's the first notice that's given under the 1999 forms, but we have it in specific terms now. And then we have the notice of determination, the notice of termination, which is basically now. And then the notice of intention to terminate will be the notice of termination, which is this ability to immediately terminate if there's bankruptcy, insolvency, or corruption. So exactly the same as was previously. We have termination for employers' convenience, which was in the 1999 form of contract. But to deal with that properly, because it has caused problems, we see that, okay, if we're giving that very powerful clause or provision to employers, you can terminate the contract whenever you want, for whatever reason. You don't have to give reasons. You can just do it because you feel like it. Then we think that it's the quid pro quo for that is that the contractor should have very certain and clear entitlements in that scenario. And so you'll see that there's two new subclauses. One for how do you value the works in that scenario, because the contractor should always be paid for the works he's actually completed, and then how he should be paid for that termination. And so you'll see in that payment side of things, you'll see wording very similar to what Odette was talking about under the White Book, and that is basically that the contractor will be entitled to loss of profit on the works that he would have carried out if the contract had not been terminated. So the contractor's ability to suspend the works is very much along the same lines as the Yellow Book, and the contractor's right to terminate is very much along the same lines as the Yellow Book. But again, we have this idea of a notice of intention to terminate and then a notice to terminate. So generally speaking, if it's not a scenario of bankruptcy or insolvency or corruption, two notices are going to be required. And that is because quite a lot of jurisdictions around the world, wrongful termination was very successfully argued by contractors in cases where it was right that the employer did actually terminate the contract because the contractor had basically stopped working and just kept a guy there sweeping the footpaths and saying that he was still on site working. So in those sorts of scenarios, we just wanted to close off that case. I won't go through this in detail, but we have the idea of a notice to correct from the engineer to the contractor in a contractor's default scenario. Basically, we have 2 new grounds for termination. The employer's entitlement to delay damages exceeds the maximum amount stated in the contract data. Okay, so that's quite controversial. I have you'll see at the bottom of my slides, I have lots of disclaimers because that's the lawyer me coming out to say that basically some of this wording might change. And that's one of the controversial ones. And that's basically telling the contractor, if you're in so much delay that my entitlement to delay damages exceeds what the limit we've agreed is going to be, the maximum limit of delay damages, I can terminate my contract with you. So that's quite a powerful clause, and I'm sure if it stays in the FIDIC contracts, it's going to lead to quite a lot of discussion. It's probably likely that it'll stay in, but I can't say for sure. And then also another ground is failure to comply with an engineer's rejection under 7.5 or an engineer's instruction under 7.6, which are the clauses dealing with defects and the contractor's obligations for remedial works. Because in practice, what was happening was that although the contractor had built something that was defective, he's under an obligation to carry out remedial works. In practice, it wasn't happening as it should do, and the employer was left trying to deal with it himself, while still paying the contractor and not being able to terminate the contract. So there's a little bit stronger provisions there. Now, bribery and corruption is quite a difficult one for FIDIC to deal with. In the interim period between the 1999 forms of contract and these new forms that are going to be published, I won't say partnership, that's quite a strong word, but the increasing cooperation, collaboration between FIDIC and Transparency International has increased on the basis that FIDIC realises that far too much money was kind of not going down the drain, but being diverted from what should be built into the pockets of people where it didn't belong. And so we basically very carefully came up with this wording here. So it's basically, when does the employer have the right to terminate the contract, or the other way around, if that party is found based on reasonable evidence to have engaged in corrupt, fraudulent, collusive, or coercive practice at any time in relation to the works or to the contract. Okay, so very kind of general words, just watch out for that, because I believe that it's going to be a ground for, in certain circumstances, a ground for threatening to terminate the contract, because we all know that contracts aren't terminated so often as they are threatened to be terminated to get one party moving when they're not. I'll skip through these because I think I'm starting to run out of time, but I've mentioned already this idea of delay damages. If the contractor is in default, not only does the employer have the right to terminate the contract, but he has the right to keep the delay damages. Okay, so that's another important point to remember, the idea of loss of profit. So when you're talking about valuation after termination, causes so much difficulties that we built in a provision for the engineer to go through 3.7 agreement of termination. And you know that's the first step then to get to DAB under a dispute if necessary. Very much along the same lines for the contractor to terminate, but we also, of course, have the idea of the contractor being entitled to suspend the works. Also, the corruption element is there. Basically, it wasn't in the 1999 forms contract. It just talked about the contractor engaging in corruptive practices. But unfortunately, regrettably, practice has shown us that the employer is too often, or members of the employer staff are too often involved in that sort of scenario as well. So we thought it was only fair and reasonable to actually build in the same right for the contractor to terminate in that sort of scenario. This idea of a second notice again, a notice of intention to terminate and then a notice of termination. Now, what happens quite a lot of the time, as you know, when you're working with in any form of construction contract, is most of the time the contractor is basically giving a notice of intention to terminate if he's not getting paid. And what happens is then all of a sudden the employer gets that, and he basically all of a sudden takes out his checkbook and writes the check to the contractor. And then the contractor goes, okay, well, that's great, I'm not going to terminate the contract anymore, but actually I didn't suspend my works, but I slowed down my works because I wasn't getting paid, and I couldn't pay my staff, or I couldn't buy the materials or import the plant or whatever. And so now I'm making a claim, and I'm entitled to make a claim under the fitted contract for that. And the employer would say, well, no, you're not. You haven't got an entitlement to claim because actually I remedied the default. I sent you the check within the period of time the FIDIC gave me. And so you've got no entitlement. And FIDIC didn't realise, it didn't agree with that at all. That's not right. So there's a new provision under FIDIC contracts to say that even if the employer does remedy his default, within that 14 days that he's got to do so, the contractor is entitled to extension of time and cost plus profit. Yeah, subject to the claims procedure if he has actually incurred cost or he has experienced delay. Now, one of the points I'm not sure whether it will be obvious to you in using the 1999 forms of contracts is that FIDIC is quite particular where it allows the contractor entitlement to cost and where it allows the contractor entitlement to cost and profit. And it took me a couple of years to get my head around why that was. And essentially, it was one of the drafters that told me it's very simple. If the employer had control over the event that gave rise to the cost, then the contractor should get his profit. If the employer had no control over the event, for example, delays by authorities or changes in law or whatever, then the contractor only gets cost. So that was always, once I got that into my head, I found that very useful. So I'll just pass it on to you guys. Okay. So we're now getting on to claims and disputes, and I'm not going to labour this because Ewan did such a good presentation this morning, but I will update you basically on some of the things. We have a definition of claim, and the reason why it was very important, or FIDIC felt it was very important to define claim and to define dispute was that unfortunately in too many parts of the world, if a contractor submitted a claim, particularly international contractors submitting a claim to government organisations, it might as well have been, it was accepted as if it was a declaration of war. And a poor German contractor would send in a claim in the innocent belief that it was entitled to do so. And the employer, when he received it, was basically marching off to the Supreme Court in the country to try and get it sorted out, which is absolutely not the intention of FIDIC, and an absurd situation. But it did happen. It happened in practice. So now we have, when the updates come out, and Ewan alluded to it this morning, we separate, because we want to make it very clear to users. You are very sophisticated users. We want to make it clear to all users. Claims are different from disputes. And so the optics of it are that the claims come under Clause 20 and disputes are dealt with under Clause 21. Very simple thing. If you remember, under the 1999 forms of contract, claims and disputes are dealt with under the same clause, Clause 20. And then we define claim to be a request or assertion of an entitlement or relief under the contract. And to repeat again what Ewan said, it's not just for time and money. It's for anything. It's for specific performance. The example that I always use is the idea that the employer is under an obligation, and he's under an obligation to give the contractor assistance to obtain permits. And all too often, unfortunately, in the past, employers just ignored that obligation because they were like, well, why do I bother? What's the contractor going to do? Nothing. There is no sanction for me not to do that. And the contractor might then try and put forward some sort of claim for damages or for breach of contract, but really it's very difficult. It's not straightforward. So we basically then wanted to make this far more straightforward and have a path, structure, certainty, then hopefully successful projects. So we have the fact that a capital C claim can be 3 different types: an employer's claim for time or money, a contractor's claim for time or money, and then a claim for any other entitlement or relief. Yeah. Including the engineer's certificate, or the taking over certificate, Behati pointed out earlier. It's a very important date. You all know that. It's basically the time where the care of the works transfers from the contractor to the employer. It's when basically the time for completion stops, or the time stops running. Insurance provisions can go over. The contractor becomes entitled to the first half of the retention money, etc., etc. So basically, this sort of claim could be that the engineer hasn't issued the certificate or something like that. It's not for time or money, and it's not for third-party claims. So that caused quite a lot of discussion from the friendly reviewers. We want to just make it clear that it's not claims under the insurance policy or something. You just, it's our idea of what should be a capital C claim. And if it's not a claim for time or money, then there's the last paragraph of subclause 20.1 deals with it, and we're talking about a notice of claim is required, but there isn't a time period attached to it. It's just as soon as practicable. And then they're basically a reasonable time for submitting the detailed claim. So that's how that type of claim is dealt with. Then we go on to the general understanding of what claim is, which is for payment or EOT. And so it's the same for employers' claims, the same for contractors' claims. We've got the notice of claim. And what I always say to parties is, really the notice of claim should express an intention from the contractor or the employer to recover time or money from the other party. And when I'm questioned, which I am quite a lot in training, as regards what constitutes a notice under the 1999 Forms of Contract, I generally say, look, it shouldn't just say that something happened and it's going to have an adverse effect on the works. I question whether something that says, this has happened and it's going to cause me delay cause me delay or disrupt the works. Is that enough? I always say to contractors, in particular under the 1999 books, a letter with notice written on it somewhere, that word, and just something that says that, and I intend to claim EOT and additional payment. Then somebody like me isn't going to have any problem at all in saying that that is a valid notice. So we've tried to build in that sort of concept into this idea of notice of claim. And essentially it is the wording of the first and second paragraphs of the Yellow Book. And then we have this idea of initial response. I don't have to talk about that because Ewan did such a great job of telling you all about it this morning. If the engineer gives no notice that it's time barred, it's deemed to be not time barred. Okay, that's fairly straightforward. We also realise the importance of contemporary records, not just for the engineer, but for DAB members and arbitrators after that. And because you guys, I'm sure, have no problem in understanding what's meant by contemporary records, we thought it was necessary to define for the rest of the world what we mean by contemporary records, which are records generated at the time, whatever it's recording is actually happening. So for those of you in the industry of claims consultancy, just be aware that retrospective programs or records won't fall under the concept or the idea of contemporary records. We have an idea of what FIDIC means by fully detailed claim. And somebody raised the question this morning as regards, well, what if there's a difference of opinion of whether between the engineer and, for example, the contractor as regards whether it's fully detailed or not. What happens in that scenario? Well, essentially, the DAB will be keeping an eye on that. That's what's expected. So if there is an issue, that would be something that the DAB will be getting copies of that sort of correspondence. The claim isn't fully yet detailed. That means the engineer hasn't started his agreement or determination. That means the DAB can get involved on an informal assistance dispute avoidance side of things. The DAB will see this exchange of correspondence. The DAB will say to the parties, this looks as if it's rolling towards something, nasty between you guys. Can we help? And then it would basically a case of the DAB being able to offer an opinion as regards whether, in fact, the claim is fully detailed or not. Now, there is I wanted to emphasise this. There is a time bar attached to this fully detailed claim, but it's only with respect to one aspect of it. And that is with respect to the claiming party's statement of the contractual basis of the claim. It's only that. So if you always have in mind that a claim will consist of more or less three parts: facts, something happened, what's the story? Law, it's either on a legal basis of the governing law of the contract or under the contract, generally speaking. Quantum, yeah? The time bar that's attached here has nothing to do with the facts side of things, and it's got nothing to do with the quantum side of things. It's only to do with the contractual basis. And there's a very good reason for that, because if the contractor doesn't take the time or the energy to actually tell the engineer on what contractual basis he's made his claim, then essentially the engineer can't do anything with it. Yeah? If the contractor has sent in the notice of claim in time and has given the contractual or legal basis, the engineer is under an obligation to consider whether the contractor is entitled to something. That's another obligation put on the engineer, yeah? Making sure that things keep moving forward, because it's when things keep moving forward that there's a higher probability of a successful project. So if nothing else, please bear that in mind. There was quite a lot of discussion. I won't say controversy, yes. I won't say ructions. I didn't go that far. But quite a lot of contractors really saw this time bar and didn't realise it was only that were giving us their feedback. Didn't realise it was only in connection with this contractual basis and thought it was a general time bar, and they really didn't like it for good reason. But that's the reason why it's there. And you'll see that there's quite a long period to actually submit the fully detailed claim, 84 days. And that increased from the pre-release version. It was 42 days. And if you imagine that 84 days is exactly the same period that the DAB has to reach a decision, it's long enough, I think. Then we have the agreement of determination of the claim. There's also claims of continuing effect are also dealt with there. Now, waiver of time limits. Because time bar is such a wonderful source of disputes and disagreements between the parties, and will probably continue to be so, we believe that this idea that in certain circumstances the time bar can be waived. Yeah, and that's a good idea, and it's a good idea to have that happening at the time that the claim is made, rather than at the end of the day when everybody's their positions have become so entrenched, and the contractor, while he would have been entitled to a significant payment of cash flow being king, if you like, that hasn't happened because a certain piece of paper wasn't submitted on the right date. So I basically, Ewan talked you through that. What I wanted to emphasise with you is that basically at the moment, FIDIC is still considering who should be waiving that time limit. Under the Gold Book, which is the Design, Build and Operate form of contract that FIDIC published in 2008, it was the DAB that was going to be waiving that time bar. And that was the reason why the DAB was in the pre-release version in December 2016. There's been a little bit of a rethink about that now. And basically we're not quite sure where it's going to go. That's why I've got a big warning triangle there. There's people that have expressed really firm opinion that it really should be the engineer who goes through the agreement determination side of things in determining this waiver, because if the parties have the opportunity in that consultation mediation stage of hearing from each other why a claim was submitted late, then it might avoid anything as regards having to go to the DAB. And there was quite a lot of discussion, if you like, on the fact that FIDIC is building in provisions for a standing DAB, which costs money, let's face it. And then every time the DAB had to do something, for example, in a time bar scenario, they were going to get paid on a daily rate for that. And it seemed to be jobs for the boys. So that was an argument that FIDIC kind of considered quite carefully. And so we haven't reached a decision about whether the waiver of the time bar we believe is a very good idea in principle, but who does it is still being questioned. It could be the DA, it could stay as a DAB, or it could move to the engineer. So don't be surprised if although in the pre-release version we had the DAB, in the new version it's the engineer. I won't say too much on this, just to emphasize we're talking about a standing DAB or a sitting DAB, whichever you like. It can be one person or three persons. Be careful of that when you're filling in the contract data, depending on the complexity of your project. We have a definition of dispute, which should make life a lot easier for DAB members, particularly if they're sitting there, because they need to know, okay, well, is this just an issue that I'm going to be giving informal assistance for? Or is this an actual dispute that I've got 84 days for, and I have to give a reasoned decision? That's really important in practice to actually keep going. Quite a lot of the time, it's probably not going to come as too much a surprise to you, but I have to say that in certain parts of the world it comes as a surprise to them. What was happening in practice is that employers are tendering under a form of FIDIC contract, and they have the DAB written into their form of contract. And the contractors really quite like the idea of the DAB being on board, because basically keeping an eye on the engineer and somewhere to go to if their backs are against the wall and they're not getting anywhere with the employer or the engineer. Unfortunately, most of the problems that have been caused around the whole DAB process is because the employer, when it came down to it, was reluctant to engage in the process. And the employer was basically trying to disrupt the process by not agreeing a DAB member. Or then maybe agreeing a DAB member or three members at the end of the day, but then not signing the DAB agreement, so the DAB member didn't know whether they were going to get paid or not. Or then not paying the DAB member. All of these games being played by employers to try and delay the inevitable when they know that they're going to have to put their hand in the pocket to pay out to the contractor, and using the DAB process and the DAB members in that way. So to close off all of that, we've basically got a lot more wording as regards how the DAB members are going to be appointed. What happens if one party, we don't mention the employer, but we just say one party. What happens if the employer doesn't sign the agreement? What happens if the amount of that should be paid to the DAB isn't agreed? And that's basically giving the authority to FIDIC, president, or whoever you'd like to name in your contract data to make the decision for you, to appoint the DAB member if they're not agreed, and to decide how much that DAB member should be paid. Okay, so there's default provisions to make sure that nothing gets stalled on the way, and to keep things moving forward. We also set out, again, for the sake of certainty, so that the DAB members and the engineer and the contractor and the employer know where they stand. We also set out, if the DAB is a standing DAB, that is appointed within 28 days of the letter of acceptance, when do they finish? Because that also has given rise to quite a lot of disagreements and problems with jurisdiction of the DAB itself. So basically, it's on the date the performance certificate is issued, but if they're handling disputes that were referred to them before that, it's when those disputes have been finished, or if the contract is terminated, there's provisions for that as well. This is what I was talking about as regards, if one of the parties fails to agree a member, or refuses or fails to sign the DAB agreement, then the appointing entity or FIDIC can actually make the appointment. Yeah. And also to set the monthly services fee and the daily fee that will be paid to the DAB member. So that's basically means that there's nothing that's going to stall things, and the parties just don't have the opportunity to start playing games with each other to make sure that a DAB is kept off the site. Ewan was great this morning. He talked about the avoidance of disputes, just to emphasise that it's only by joint referral by the parties. So both parties have to want the DAB to give their opinion on something, or to give their advice on something, not just one party. And DAB members, if you're sitting in the audience, you need to be very careful that you just don't allow one party to go, listen, can you give us your view on this so we know where we're at? And they don't turn to the other party and go, do you agree? I mean, it can't be in a meeting and everything, that's absolutely fine. Ewan pointed out that there's to be no DAB interference with the engineer acting under 3.7. Now, if you heard that this morning and you were questioning why is that the case, just remember, FIDIC is the Federation of Consulting Engineers. It wants its engineers to do that job, and it certainly doesn't want to create a situation where there's absolutely too many cooks stirring that broth between the parties that's already been bubbling away on the basis that it's a dispute. So it's basically trying to put a firm line between, okay, Mr. Engineer, here's your role, and Mr. DAB panel, here's your role, basically, because they're all going to be on board as part of the project team, if you like, from the very beginning of the contract. Now, this is one I just wanted to highlight to you. The DAB can give assistance, this idea of giving an opinion or advice during any meeting, site visit or otherwise. That's fair enough, that's fairly straightforward. And it says, but unless otherwise the parties agree otherwise, both parties shall be present at such discussions. And I wanted to emphasise that to you because that's kind of fairly wishy-washy wording, but it's essentially saying that the DAB should be dealing with the parties even-handedly. And unless the parties agree otherwise, they meet with both parties together. Yeah? Because there's a type of a conciliatory, mediatory role being played here, if you haven't spotted it already, this idea of dispute avoidance. It's expressing a view and hoping that the parties will avoid that becoming a dispute somewhere down the line. My own personal view, and it's not FIDIC's view because FIDIC has said, unless the parties agree otherwise. My own personal view is stay away from caucus meetings. Don't get involved in separate meetings with one party, whether you're a DAB member or a party, because it leaves it too open for, if the same issue then goes on to become a dispute, it leaves it too open for one of the parties to claim that the DAB is not impartial any further. They've gotten information that in that private meeting that basically you didn't have access to. And so that fundamental concept of neutrality, impartiality, independence of the DAB is bound to suffer. So FIDIC wanted to keep it open and keep things flexible for the parties to decide themselves or agree themselves. My own personal view, and I stress that it's my personal view, is don't go down the route of separate meetings. Okay, and Ewan emphasised already that the parties aren't bound by any advice in that scenario. But again, I would say that it would be unlikely, particularly in the case of a three-party DAB, it would be very unlikely that three people sitting on a panel would give you a view today, and then 3 weeks from now, when they're looking at your dispute, that they would come up with a different view. I mean, it's just unlikely. So that's worth bearing in mind as well. We have the reference of the dispute within 28 days after the notice of dissatisfaction, and if not, the notice of dissatisfaction shall be deemed to have lapsed. So that's the notice of dissatisfaction to the engineer's determination. Now, you might question why that is so, and that is essentially, very simply, keep things moving forward. Yeah, it's if you have an engineer's determination, one party has said it's not satisfied with it. The DAB is sitting waiting for disputes to come to it, and so disputes should actually be referred by one of the parties within a certain period of time. We're still going to have this idea of 84 days. Just to say, as in the 1999 forms of contract, it can be another period agreed with the parties. But FIDIC and the ICC and people that are getting involved in dispute boards more and more often are starting to frown upon DAB members that keep asking for extensions of that 84 days. So that's a serious trend that's out there at the moment. DAB members now are going to be expected to stick to that 84 days as close as possible, and only for good reason for that to extend. It's certainly not the idea that, you know, it's instead of 3 months, the DAB is allowed to have 18 months to reach a decision, although, you know, it might be appropriate that they have 10 months, for example, if it's a complex dispute. Now, Ewan pointed out this morning that when a DAB reaches a decision, if an amount is due to be paid by one party to the other, it's immediately due and payable. And Ewan had in his slide this morning about the fact that on presentation of invoice. That's now even been taken out. Because if a DAB reaches a decision, it should be due and payable, whether there should be no preconditions attached to it. So basically not even having to generate an invoice. Now the parties can agree that for the paperwork and everything that an invoice should be submitted, but it still means that the one party has to pay the other. What else have we got to say? I like this. Sorry. I wanted to emphasise as well, I can't remember which slide it's on, it might not be on this slide. In the pre-release version, if you remember, there was a period of 182 days within which the DAB decision had to be referred to arbitration. You've no idea how much discussion that generated. So we've taken it out. It's no longer the case. What we were trying to basically continue this idea of moving the dispute forward towards arbitration. We thought that by giving it a period of 6 months, it would be long enough. And, at least people would have the answer. But we got so much feedback to say to us, look, arbitration is really serious. Arbitration is no longer cheap and cheerful like it used to be 20 years ago. It costs a lot of money. It takes a lot of time and effort. It's serious stuff. So there shouldn't be a scenario where you have to push a dispute towards arbitration just like that, because the only people that will benefit will be the lawyers. And for us engineers, that was enough. That's all we needed to hear. So we basically thought, okay, we'll take that out. If a contractor or an employer is so keen to proceed to arbitration, they're going to do it themselves anyway. Okay, so that time limit isn't in there anymore. It's just been deleted. But I'll take credit for it. Here's a provision that I added in, or that I sort of put in there then for everybody to discuss, and it stayed in there, which I'm really quite pleased about. And that is that once you're in arbitration, and you've gotten to the end of the arbitration, and the arbitrators are now looking at costs. And as you all know, that's one of the most important aspects of arbitration, as opposed to adjudication or anything, is that the arbitrator can award costs of the parties, not just of their own costs. That basically the arbitrators, this allows now, in the arbitration clause itself, so it's part of the arbitration agreement, which is severable from the contract, the arbitrators are now authorised to look to see if one of the parties could have constituted a DAB, but didn't. And that meant that the other party had to push the dispute to arbitration, thereby incurring such high costs. So we're hoping that will focus people's minds to basically making sure that they go down the DAB route, because as Ewan pointed out, one of the last subclauses of the new updates is 21.7. It says, if there is no DAB in place, the dispute can be referred directly to arbitration. Can you remember that? And that's to make sure that the party has a place to go, yeah? This says then that if you're in that arbitration or a similar type arbitration, and one of the parties has been dragging its heels or caused the DAB not to be constituted, not to be put in place when it should have been put in place, the arbitrators can take that into account in determining the costs allocation. So we're hoping that that's going to have a powerful effect in making sure that both parties are on board and engage with the DAB when they should do. I'll skim through this, but this is, as you're aware, the DAB rules are also published with the actual books towards the back. There was talk about whether they should be published as a separate document. Somebody, I think, mentioned this morning that as regards dispute avoidance, that maybe FIDIC were paying attention to what the ICC were doing. No, nobody said that? That wasn't the case. We were working with the ICC at the time. They took on board what we were saying to them as regards dispute avoidance. They published revised rules for dispute boards in 2015. Myself and a couple of other people were very closely involved in their work, because originally FIDIC was not going to have its own dispute board rules. It was going to use the ICC rules. Eventually FIDIC decided it'd like its own rules specifically for engineering projects. So that's the way it went. This question of a standing DAB plus versus an ad hoc DAB, that's already been decided. The default is standing DAB, but there will be provision in the guidance notes if you, the parties or the employer, wants to have an ad hoc DAB. And I'm being shown Ian's watch, so I'm going to speed up. We talked about dispute avoidance. I always get asked, well, first of all, people say, oh, Siobhan, you're a dispute adjudicator. Of course you're going to build in standing adjudicators because you'll get paid a fortune on a retainer basis. And I always emphasise that basically the DAB is expected, they're not going to get paid money for nothing. They are expected to earn their monthly fee as well as their daily fees in keeping up to date with the works. And in essence, that money is a little bit like an insurance policy to prevent disputes actually happening, because disputes distract from the actual work that should be happening by the employer's people, by the contractor's people in actually getting the job done. And I think I'll finish up there. We've got correction of the DAB decision. Interpretation of the DAB decision might be interesting to contractors in particular. You can ask the DAB to basically give you, if you don't quite understand it, particularly in international projects where the DAB decision might be written in English, but that's not your mother tongue. You can ask the DAB for interpretation. If the DAB thinks you're messing around and asking for an interpretation, they can decline to give one, because unfortunately parties sometimes use that as a way of trying to get a different answer to their question before they go off to arbitration. Challenge of a DAB member. Again, regrettably, some DAB members out there that were practicing weren't impartial. They were biased, and they indicated a bias towards one party or the other. They thought that because they were nominated by one party, that they should, take that party's position in, particularly in 3-member DAB. So we have this idea that the parties or the other members of the DAB can challenge a DAB member, and the president decides. Resignation or termination, fairly straightforward before, and I spoke about DAB fees. And just to let you know that to date, DAB, there aren't a lot of properly qualified DAB members around the world. And so FIDIC, very shortly, I had hoped that it would be in place by now, but it's unfortunately not the case. FIDIC is engaging in a new initiative to train arbitrators or mediators and adjudicators to become DAB members, because it's a different type of process. And also to assess FIDIC, people that are out there that think that they would be good dispute adjudicators, so that they can then get on either national lists of DAB members or the President's list, which is taken to be for large-scale international projects. And that we hope then that will mean that there's more choice for people, because one of the things I didn't say was that the contract data for the new updates will have provision for 3 names of DAB members to be put forward by the contractor, and a separate 3 names to be put forward by the employer, with the idea that the 1 person or the 3 people DAB panel will be chosen from those 6 people. Yeah, that's the way basically we hope to get agreement between the parties for the DAB members, as opposed to having to go to an appointing entity to get them appointed. And I spoke about the Yellow Book. I can safely say that the Red Book is going to be very much along the same lines. There's really going to be minimal differences between the Yellow Book and the Red Book, apart from this idea of design. And so you'll see that Clause 5 and Clause 12 are very different. When it comes to Clause 12, when we're talking about measurement of the works, if there's a dispute as regards to the measurement, whether it's on the rate side of things or the quantity side of things, it goes to the engineer for agreement or determination under Clause 3.7. That's what I've highlighted there. But there are some minor changes as well, but basically it's going to be very much the same. So when they come out, my recommendation to you will be get hold of the Yellow Book, become familiar with that, and then you'll be able to track back and see what the changes are to the Red Book. And then under the Silver Book, again, very much the same as the Yellow Book, except an allocation of most risks to the contractor. And really that means that all of the places where it said that subject to Clause 21.1, subject Clause 20.2, the contractor shall be entitled, just delete that clause. So that means that the employer doesn't have that risk, the contractor doesn't have that ability to actually claim for it. Yeah, it's more or less the same. The other main difference, I think, under the Silver Book is that the employer is under an obligation to appoint an employer's representative. It's very important that the contractor knows who in the employer he should be dealing with. And that has caused a lot of problems in the past on these EPC turnkey contracts, which are very much hands-off from the employer. And we need to have one person involved in agreeing or determining claims under the Silver Book as well. So the provisions aren't exactly the same as under the Red Book and the Yellow Book for this idea of agreement or determination. They're slightly different, but very much along the same theme as regards, a fair determination. Thank you very much. I'll answer any questions.